The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barquette, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
Good morning and welcome back to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. From Cook, Barquette, Ponder, and Wolves, I'm Matt Glenn alongside my partner Dan Grimm. Dan, how are we doing today?
Fantastic.
Outstanding. So did you bring us a guest?
Well, we brought the best guest ever.
Oh, come on.
Yourself.
Well, I can't disagree at all with that comment, actually. That's well-deserved on my part. I appreciate that.
Today's all about you.
I understand. And I understand why. It's because I used to work for the dark side.
So I've been told.
Yes. So we're going to give the defense attorney's perspective on these personal injury cases.
Yeah, and so I think this gives a unique perspective because you were on the dark side or the defense side for several years, and now you've been moved over to the good side, the white hats, if you will, for several years. So I think you have a unique perspective because you've seen what's on the other side of the curtain.
That's right. For years, I defended poor, helpless, massive corporations against powerful individuals that tried to take their money. And it's amazing no one ever wrote a folk song about what I did. But you're right. I've always said that you shouldn't be a prosecutor if you couldn't be a defense attorney because you need to be able to have both perspectives. And I don't think you should be a plaintiff's attorney if you couldn't be a defense attorney. It doesn't mean you ever spend time doing it or that you want to, but that you need to be able to kind of have that perspective in order to adequately represent your clients.
Absolutely. And so I guess with that in mind, let's just talk a little bit about you as far as your personal background and let's talk about where you went to school and a little bit about your legal background.
Sure. Well, I grew up in really two places, a farming community in the middle of Kansas called Salina. It's kind of like Cape Girardeau, same size. Hub community serves a lot of farms around the area. So you got a lot more amenities in a town that size, kind of like we do here. Spent my teenage years out in South Carolina trying to dodge a southern accent, and then found myself in law school in St. Louis, Missouri at Washington University School of Law. Spent 2 years in practice back in South Carolina at a large law firm. And then when we wanted to start a family, my wife's from St. Louis, so back to St. Louis we went and caught on there at Nationwide, where I was in-house for 13 years before transitioning over to the office where I am now.
And so, with your experience at Nationwide doing defense work and then with your experience at on the plaintiff side doing plaintiff's work, I mean, I've seen you. You are a absolutely fantastic, amazing trial attorney.
Thank you.
I've seen it firsthand. I've seen you in trial. It's very impressive. But I mean, I'm kind of curious about is what skill sets do you think that a defense attorney needs that also maybe translates over as a plaintiff's attorney?
Well, in terms of trial experience, it really is, or trial skills, it's really doing it. There are not many places now that will train you to become a trial lawyer, that will actually give you the opportunity to go into court and try a case. We had Jacob on the show a few months ago. He's tried 2 cases by himself, and he's second chaired another one, 3 cases, and he's been out for 4 or 5 years. I bet he has more trial experience than almost anybody he went to law school with that isn't maybe doing prosecutorial work with a prosecutor's office. The way to get good at something is to practice it. And the way you gain your trial skills is by getting in the courtroom and actually doing it. And so that's really the key. I tried 19 jury trials during my time in-house at insurance companies. And, they're easy on the defense side, much easier than they are on the plaintiff side, and also less rewarding.
Yeah, and I think that, analogy would be you wouldn't ask a non-surgeon to do surgery.
Exactly. And the first time a surgeon does surgery, that surgeon's probably in there with some really experienced surgeons walking him through everything.
Oh, absolutely. So on the defense side, obviously when a case is filed, a civil case, what is some of the factors that a defense attorney would look at in evaluating a case?
Well, you obviously have to look at liability and you look at what you know about damages. But oftentimes when the case comes in, you really don't have a lot to go on. You've got a petition, what's been filed by the plaintiff. And what you can tell by that is basically their allegations, but you can also tell who filed the case. And that was one of the first things we always looked at. There were certain attorneys that we knew would never take a case to trial. And if we saw them at the bottom of a lawsuit, we would know that, okay, well, we're going to do some discovery, we're going to do some depositions, and then we're going to make them an offer. And the offer we make them is going to be quite a bit lower than the offer we might make somebody who we know goes to trial, because we know at the end of the day, they have to take it. They have no choice but to take it at the end of the day. So,
So something you're looking at is the individual attorney that's handling the case as well as the law firm?
Absolutely. Not every lawyer out there has the resources necessary to go to trial. Not only go to trial, but then if you win, to guard your result on appeal, which can take months and require a lot of brief writing.
And when you say resources, a lot of the folks that are listening out there today, they've never been involved in a motor vehicle crash or ever been involved in a litigation. What do you mean when you say resources?
It's everything from attorney power, actual people power, to actual money. We've got a couple of cases right now that are on appeal. We've spent, I'd say, on average, $25,000 to $30,000 to get those verdicts, and that's actually on the cheap side. Those are relatively inexpensive verdicts. Those cases are both post-verdict and are both being appealed. When a case gets appealed in our office, Kathy Woles and Matt Davis will pick up the trial transcripts, 3 days worth of attorneys talking, and they will write legal briefs based on those trial transcripts and fight our case at the Court of Appeal level. If necessary, we might win at the Court of Appeals, or sometimes we lose. You go from there to the Supreme Court. So it becomes a 2 or 3 year battle in the appellate courts that if we didn't have Kathy Woles or Matt Davis, we're not able to engage in that battle. And on the defense side, we know who the heavy-hitting firms are. We knew when Mike Ponder filed a lawsuit against us, okay, this case has value. Right, and if we don't put the value he wants on that case, he's going to take us to trial. He's going to hire the right experts. He's going to pay those experts to come to court, and he's going to have 2 or 3 associates or partners of his working the file with him leading into trial. So he's not doing all of that by himself. We knew he'd put on a heck of a show at trial, and that most of the time he wins. So we understood, based on what firm was at the bottom of the lawsuit, exactly what we were getting into.
And what about as far as looking at, as far as collisions? Do you look at things as far as damage to the vehicle, the impact? I mean, what are the things when you first get a file on your desk? What's some of the first things you're looking at?
Absolutely. We get a lot of photographs. We get police reports. We, can sometimes gauge the speed of the cars based on sort of the amount of damage done to the vehicles. That all factors into, our in-game strategy, which is we know at the end of the day as a defense lawyer, it's the same thing we know as plaintiff's attorneys. You have to go into a courtroom and argue to 12 people that you don't know and that you'll never see again that your client's position is right. And those people tend to do what is reasonable. They tend to follow the evidence. And so you're looking at the damage to the vehicle and saying, okay, they're claiming, sort of multi-level disc problems, but there's no visible damage to the back of the vehicle. That's something that they're going to have to explain. We need to figure out how they're going to explain that. There might be, we might have some evidence of a prior injury to a neck that, may have an impact on, the current condition of their injury. We may need to look into that and see what evidence we can find that maybe this pre-existed the accident. And at each stage, you're looking at, how does this look to the average person? What arguments can I make based on that?
Sure, that goes to as far as possible liability defenses. If there's multiple vehicles involved or is it intersection collision, do you evaluate liability issues?
Absolutely, and that becomes really important in our premises cases. Every slip and fall in a grocery store is defensible. And what defendants don't know and what plaintiffs don't know is that oftentimes when they're trying to say things that make their case look good, they're actually making it look bad. I've had clients come to me as defendants and say, Yeah, we saw a little bit of oil on the ground. It was tiny. It was only like the size of a silver dollar. It was just so small that I can't imagine anybody would slip on it. And I would say, well, here's a videotape of somebody slipping on it. And because you're telling me it was tiny and so small, that's going to be really easy for the plaintiff to explain how they didn't see it. And yet you're going to have to explain why it was on your floor. And so they think they're arguing, oh, it was such a tiny little patch of ice or a tiny little piece of liquid. They think that's good. Well, it's good and it's bad. And so, you go through that sort of evaluation process on a litigation phase. And I was constantly telling my clients the same thing I tell them on the plaintiff side: get your lawyer involved early, because you want to talk the truth through with your lawyer so that your lawyer can then educate you on the law and figure out what your best case is. That's the lawyer's job. It's never the client's job on either side.
So true. What about cases on the defense side that you see might have quote unquote heat in it as far as like inflammatory issues? And obviously the thing that comes to mind is like if there's an allegation of drinking and driving.
Right. Yeah, we did have those, and that oftentimes could put the defendant at odds with their insurance company, which would create a lot of issues for people on our side. But we would look at that and we would explain to the insurance company that, look, because this person was, drinking and driving, or because they were, driving 85 miles an hour in a 55, and, oh, by the way, they have a history of speeding, we're going to have to pay a premium on this case. You can't simply look at the injury and say, okay, this is what the injury is typically worth. You have to also look at the fact that, the jury's probably going to punish this defendant a little bit for some understandably pretty bad conduct. And yeah, we wind up at the very beginning, or as soon as we get that information, adjusting our value of the case.
What about, I guess, besides drinking and driving, some other things that have popped up that have been issuing cases is cell phone use.
Yeah.
Does that have the same type of heat?
It has almost more heat than drinking and driving sometimes. People are very, very frustrated when they are at a stop or when they watch people drive down the street and the majority of people are looking down at their phones. And it is distracted driving is a huge issue today. And there are now ways that we've done this on the plaintiff side. You can get the data from people's cell phones and see that they were streaming a video at the time the collision occurred. That's something on the defense side that we would try to grab that information early on. We would try to, all right, were you on your cell phone? No, prove it to me. Show me your call record. Show me your data streaming records if you've got them, or we would get them ourselves. And we would tell them, if you're sure that you weren't watching a video or streaming a video at the time of this accident, then we're going to get this data and prove it. Because I've actually talked to jurors after a trial where they have told me, oh, we knew what was going on in this case. We knew that one of the drivers was on their cell phone. And there'd been no evidence of any cell phone use in that trial. The jury made that assumption based on their experience of observing almost everybody on those devices. And it becomes a huge issue.
And so on the flip side, too, as a defense attorney, are you trying to get the plaintiff's cell phone records
Absolutely.
As well?
Yeah, immediately.
Whether it's texting or talking or streaming videos.
Everything we can get our hands on. Right. Yeah, we're absolutely running everything down. It's of no cost to the defendant to do that. As a plaintiff's lawyer, if you get it, you have to turn it over to the other side, arguably, and you may discover some stuff that you don't want to discover. Not every defense attorney would ask for it. We would. We would ask for it, and oftentimes it would prove that the plaintiff was not on their cell phone, and we would move on.
What if you do on the defense side? If you saw a plaintiff was on his cell phone, how does that affect your evaluation of the case?
Yeah, it depending on how the accident unfolded, depending on whether this is an intersection collision or whether we feel like the other driver should have seen us, it can really have a negative impact on the value of the case, and it certainly has a negative impact on what we're willing to pay in settlement. So that's going to do it for segment one of Tell Me I Have a Case. Apparently, we'll be back in a few moments with me alongside Dan Grimm, talk a talk a little bit more about the defense perspective. Best interviewer ever. Defense perspective in personal injury cases. Thanks for listening.
Cook, Barquette, Ponder, and Walls are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
And welcome back to segment 2 of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. I'm Matt Glenn alongside Dan Grimm. Today we're talking about the defense perspective, which means your guest is me. So we were talking before, Dan, a lot about electronic devices and cell phones and the importance of those. What other topics did you want to get into today?
Yeah, I think every case, is something that we look at. I'm sure on the defense side, they look at is the thing that's quote unquote called a gap in treatment.
Yeah.
So crash happens, and from the defense side, they refer to it as a gap. What they're looking at is, I guess, from the time the crash occurred to the date of the first treatment,
right,
or gaps in between treatments thereafter. Tell us, for the defense side, how does that affect your evaluation of a case?
It can have a really large impact on it. I think if somebody is hurt in a crash, we expect them to be at a doctor within 24 hours of the crash. If they go straight from the scene by ambulance to the hospital, then there's no question but that they were hurting at the scene. People don't tend to want to go to the hospital, certainly don't want to ride in an ambulance and risk having to pay for that themselves unless they're hurting and feel like they need to get checked out. We often saw people who would tell us, gosh, I woke up the next day, I felt awful. I thought this will go away in a day or two, and by day 3, I just couldn't handle it anymore, so I went to the doctor then. That's a 3-day gap, but that's a gap with an explanation. And, you often see gaps because people's lives get busy. The question is, how do they explain them? And that really becomes the key. On the plaintiff side, we're always sitting with our clients saying, okay, explain to me then why there was this 3-month gap in treatment. And, you get every answer under the sun from, I just didn't feel like going anymore. Sometimes they say, you know what, I didn't think it was helping me, so I stopped going. And then when I went back to my doctor, the doctor said, no, it's important and this is why, and sent me back, so I started going again. That's a reasonable explanation. I would take that on the defense side. But I just didn't feel like it, and I haven't been back in 3 years. At that point, most of those jurors that we talked about earlier, I think they're going to look at that situation and say, yeah, well, you haven't been treating for 3 years. You're not hurt.
Right. Yeah, that's something on our side as far as when we represent clients. It's something we always look at. And you're right. It's important to have a common sense explanation. Yeah. And when you can't, or when you don't have that, it provides leverage for someone that's on the defense side to make hay out of it.
Exactly. And that's why it's really important to just talk it through honestly with your attorney. We can make your explanation look good, but we just need to know why. Why didn't you go? Most of our clients are reasonable people, and they do things for reasonable reasons. And so we can usually put a decent spin on it, but we need to know, why they didn't go. Was it a financial reason? Did they lose transportation? Did their mother get sick and they were caring for them full time? What kept them from the treatment? And then you can kind of explain that gap, which really negates the defense advantage from it.
And I guess on the other side is that then I know something as far as a lot of times when you're dealing with soft tissue cases, it does take time for things to develop. But along that same vein is the nature and severity of the injury. Right. Broken bones versus soft tissue. Kind of explain how you on the defense side would evaluate the nature and severity of injuries.
Well, you're looking for potential permanence. And so with broken bones, if it's a fractured arm or fractured lower leg or fractured rib, typically those would heal. Sometimes they required a surgery, but usually they would kind of heal and the person would kind of get back to normal. With soft tissue, it was a little bit more dicey.
And explain with soft tissue.
All right, so soft tissue is an injury to any part of your body that isn't bone. It can be a disc, it can be a muscle, it can be a tendon. It can, anytime you hear about an athlete going down with a knee, needing knee surgery, a ruptured ACL, that's a soft tissue injury. Mm-hmm. They've torn their meniscus, they've ruptured a couple of tendons. Now they can't walk. Doesn't mean it isn't serious, but it's a quote-unquote soft tissue injury. When you're looking at neck and low back injuries, which the majority of car accident cases lead to that type of an injury, what we're looking for on the defense side is the first complaint of what they call radiating pain. And that's the first clue to me as a lawyer that the pain is impacting a disc in the neck and it's shooting a pain signal down the person's arm. or at least that's probably what's going on. That is a red flag to a defense lawyer who's then going to say, you know what, this person might be a candidate for surgery one day. And you adapt your case on that side very quickly when you see something like that.
And still talking about injuries, what about if someone in the medical records is seeing a doctor and the doctor recommends surgery, as opposed to you get the records and you see that surgery was done? How does that change your, or if at all, your evaluation of the case?
I don't think we ever had success in our office, myself, my boss, the other lawyer that was trying cases. I don't think we ever had success arguing that a surgery that had already happened wasn't related. If the surgery was off in the future and was a possibility, maybe it had been recommended 1 year and we're in trial 2 years later, we would have our doctor saying, no, they don't need surgery. The plaintiff's doctor would say, oh, no, yes, she will need surgery. If they hadn't had the surgery, we had a fair amount of success arguing to a jury that it's not related. We had a lot more. We had, like I said, no success if the surgery had already happened.
Interesting.
By then, the ship had sailed.
Interesting.
Yeah.
Yeah, because a lot of times, obviously, there's clients that, and I imagine the same thing. Surgery is very risky. Surgery is scary. Surgery means you may be down and out for a while.
Yeah.
So a lot of times, clients want to push off the surgery as long as they can. How does that, when you hear from a plaintiff's side, that explanation, you as a defense attorney, does that change your evaluation? Or
Well, we tell the adjuster at that point, look, there's risk that they're going to be able to pull this off. If they've hired a good lawyer, if they've hired somebody that's tried a lot of cases, we know they're going to come in there with a good explanation as to why this person hasn't gotten the surgery yet. And that a lot of juries will buy that explanation and will pay that plaintiff for that future surgery. We adjust and we say, yeah, this is a recommendation. There's a risk here of a verdict. You remember an insurance company, they're actuarials, right? They have 1 million of these cases. An individual has one. So the insurance company looks at all of the cases they have that are almost identical with future surgical recommendations, with clear liability, and they do the same thing on every single one of them. They put X amount of dollars on almost every single one of them. Now, that's a good bet for them, right? They're going to come out ahead even though they're going to lose some of them. The trick for our clients is figuring out, this is their only case. Do they have one of the ones that is going to go above the range, or do they have one of the ones that's going to come up short? And oftentimes, in my job, I would call them and tell them, hey, look, the attorney I have on the other side of this is one of the ones who typically beats this range. If we can get out of this for an extra $20,000, $30,000, we really ought to consider doing it.
Interesting. Yeah, another thing I think is fascinating as far as age of the injured party. So you could take two people in the exact same car, clear liability. I represent one plaintiff, somebody else represents another plaintiff, and one plaintiff is 70, the other plaintiff is 18.
Right.
Exact same injuries.
Right.
You as a defense attorney, do you evaluate those injuries, the evaluation of those injuries differently because of the age?
Yeah, I mean, and it cuts several different ways. If the 70-year-old is telling us this impact caused me to, be in a ton of pain, it's debilitating, I can't really do my daily activities, and I'm not getting any better. That's easier to believe than an 18-year-old who is a lot younger and should bounce back a lot faster. Then again, if an 18-year-old goes through with a neck surgery and gets, say, a fusion done in the neck, we know that 18-year-old is probably going to need 2 or 3 more fusions as they live another 50, 60 years. And that also causes us to increase the value of that claim. It's also going to impact an 18-year-old's work history. I'll give you the best example I ever had was a kid in central Missouri, just outside Kingdom City. And he was 18 months old, and he'd gotten a really bad accident with a Mack truck on the other side of it. And he had to have a fusion in his neck, an 18-month-old. I had never even heard of such a thing. They actually cut a bit of his rib out and turned his rib into a neck bone and fused it. Well, that meant that part of his neck was not going to continue to grow and develop. They did it essentially to save him from paralysis. Well, now this kid in central Missouri His mom works at a gas station as a cashier. Dad works as a warehouse man, both physically demanding jobs. One of the central avenues for a kid to better themselves from that part of our state, in that situation, is join the military. That avenue is now closed for that kid, right? That he's not going to go to college on a GI Bill. He's not going to go to college with an ROTC scholarship, and his parents aren't going to be able to afford higher education for him. And yet, physically, he's not going to be able to do the same job his dad can do. That case was worth every dime of insurance we could get our hands on, and then some. I mean,
So what you're saying, so younger injured plaintiff, he has a long runway ahead of him, decades and decades and decades of life.
Absolutely.
It affects quality life, his essentially earning capacity. Those are things you factor as an age factor, as opposed to someone that may be 70 that has the same injuries.
Yeah, absolutely. I mean, again, the injury is more believable to a 70-year-old. So if you have a lower impact and the 70-year-old is claiming an extreme injury versus an 18-year-old, you're more likely to believe the 70-year-old. But yeah, the potential damage, the younger you are, the longer you have to live with it, it can really increase the value from the defense perspective.
Interesting. What about as far as something that has been an issue for the last 10 or 15 years, is the social media issue?
Yeah.
How does that, when a case comes in, is social media something you look at?
Absolutely. And we tell our clients all the time on both sides, stay off social media after you have a case, because I don't care how many medical records and doctor visits that you have. I don't care what your MRI says. I don't care that your surgeon says you need 3 levels of your low back fused. If I have a picture of you swinging a golf club at a golf course, the defense attorney is going to win with that picture. If you say that you can only, if you ride your motorcycle, you're going to be in great agony after you do, and then you go on vacation on your motorcycle to a place 4 hours away, and you hop off the bike and immediately take a photograph of yourself with a huge smiling grin on your face, that picture doesn't reflect a person in pain. And so jurors tend to mistrust almost everyone until you can prove you're trustworthy. And if the pictures you put on Facebook, which they believe are honest representations of who you are in that moment, if they contradict the story that you're telling them, you've got a credibility problem, and you've created it for yourself. Stay off of social media if you get injured and you want to potentially file a lawsuit. It is the number one way I saw clients derail their claims.
I agree. And same thing as with medical records.
Yeah.
What are you looking for in medical records when you're evaluating a case from a defense perspective? Things that maybe a plaintiff says or does, or
Yeah, we saw a lot of them get tripped up on their past history. Most people have had a back issue at some point in their life or a neck issue. The only time it became a real problem for plaintiffs and a real boon to the defense side is if the plaintiff lied about it. If the plaintiff thought, I can't talk about this prior back issue because I feel like it'll hurt my case. And they weren't honest with their lawyer, and they weren't honest with their doctor. And we would find medical records from 2-3 years prior to the accident showing that they had these consistent low back problems or neck problems, and we could go and we could take those records and put them in front of the plaintiff's doctor, who would then kind of be embarrassed that the plaintiff had lied to them and said, no prior history of back problem at all. And then suddenly all these records come in. That upsets the doctor. You've made him look bad, usually on camera. Whereas if the plaintiff is honest about that and talks to the doctor about, well, this is how my symptoms changed. This is what's different now versus then. It had gone away. It had been gone for, 2-3 years. That's an explainable defect in the case. But by lying about it, the plaintiff has derailed their claim.
And I expect that you're constantly, on the defense side, as a defense attorney, do you have constant contact with the adjuster? Are you reevaluating the case and giving the adjuster your thoughts on how the case may change, either for better or for worse?
Yeah, and we were always looking for reasons that it had changed. If I got a record in from a surgeon saying, yep, I'm going to have to operate on them, and I'm scheduling this surgery for 1 month from today, we're going to do a disc replacement at the L5S1. I call the adjuster up and I say, look, this is going to happen. This is a $100,000 surgery. Their doctor is going to say it's related to this accident. We can find a doctor who will say otherwise. But that's how this case is now changed, and we need to change our evaluation of it. And good adjusters will. Good adjusters and good attorneys will.
That's great information, Matt.
I appreciate it, Dan.
Fantastic. Fantastic.
I've never seen a better interview done, and it's a shame.
What'd you say?
And it's a shame.
No, but never seen a better interview done.
Never seen a better interview.
Right.
So our apologies to Dan Grimm. We ran out of time today. We'll try to get to him next week. Thanks for listening to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Dan Grimm, I'm Matt Glenn. We'll see you in 1 week.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.